Hello, I'm Brian Roten, Senior Reporter for Hotel News Now, and I'm here with Randy Coffey, partner at the law firm Fisher Phillips. Today, we're going to talk about the Supreme Court case that led to the Chevron case from back in 1984 being overturned. Thank you for being with us here today, Randy.
Happy to join you.
So, uh, let's just jump right in and let's set the stage for our listeners. Can you give us an overview of the Chevron case and what that meant at the time and for the last 40 years for federal agencies and for the businesses that had to follow their rules and regulations?
Sure. So Chevron was a decision that came up in the environmental context. And there were a number of cases prior to that time where periodically the Supreme Court had granted deference to agency interpretations of regulations to some degree or another. In the Chevron case, and it was only a plurality case because a couple of the judges had recused themselves from hearing that case. And what the court then said in Chevron was the first question that a court needs to ask is whether there's a clear direction from the statute that Congress enacted. If so, that's just to be applied. But if the statute were silent or ambiguous on a particular issue, then the question became um, the court would look at the agency regulations, and if they thought that the regulations were a quote permissible construction of the statute, then they were to defer to the agency interpretation of the statute. That resulted in almost all regulations that were subject to being reviewed when the statute was deemed ambiguous or silent being approved by courts. But there were then back and forth, swings between administrations altering the regulations. And so there was a lot of differential, uh, results depending on the time when the regulations were reviewed. And over time, the Supreme Court refused in a number of instances to apply Chevron deference, or it limited the scope of Chevron deference in certain cases. And ultimately, what now has happened is the court says Chevron deference is just unworkable and it assumes the task that the Congress and the Constitution have granted to the court to say what the law is.
Gotcha. So, what can you tell us, more detail-wise, as far as the latest case that you just referenced, the one that overturned the Chevron deference?
Sure. So Loper Bright was a case that involved fisheries and regulations relating to boats that were going out and having inspectors on those boats. The agency had required the boat owners to pay for some of the observers on the boats, although there was no um, mandate in the statute for that to occur. And what Congress said in the statute simply didn't cover what the agency was doing. And so the court looked and said, well, we have this statute that was enacted in 1946 called the Administrative Procedures Act that tells us how to look at regulations that are enacted. And what the statute said, as well as the excuse me, the constitutional provision saying the court is to decide cases and controversies, and it's their obligation to say what the law is, which goes all the way back to the very beginning of the United States under the Constitution. This statute specifically says that the reviewing court shall decide all questions of law. And so the court looked at what had developed under Chevron, and basically they said, look, the first part of Chevron clearly is correct, which is that if the statute specifies and Congress has mandated certain things to happen, the court applies that result. But on this issue of whether the statute is ambiguous or silent, there is no reason to defer to agency interpretations because it's the court's obligation to construe the law. And all of this deference issue really obfuscates what the real question is, which is, does the statute authorize the challenged agency action? And the court said, it's our obligation and the obligation of the lower courts to give the best reading of the statute and to resolve the ambiguity. That's not an agency function.
So, uh, the case from the 80s that was dealing with, environmental protection, the EPA, this one dealing with, fisheries, but this is going to have wide-reaching effects on uh, many different industries. And what I'm interested in today is particularly on the labor side. Just when you think about all of the different rules and regulations that apply to businesses under the Department of Labor, what can you tell us this is going to mean for the rules and the interpretation of those laws by the Department of Labor and its different subdivisions, and what this is going to mean for employers generally?
Sure. So this ruling will have effect on every agency that issues regulations, and that means everyone from the Department of Labor to the EEOC to the National Labor Relations Board, the FTC's recent efforts to eliminate non-compete agreements. All of those things will be subject to challenge by people affected by them. And the question in each case will be, is the regulation consistent with and supported by statutory language? And the court will then have to say, this is the law, and does this regulation comport with what the law and the statute is?
So, let's go, agency by agency. You would, before recording, you had mentioned that you have a specialty in the EEOC. So let's start there and talk about what you see happening with, rules and regulations under the EEOC and how, court challenges are likely to go there.
Sure. So the EEOC has really two kinds of statutes. One where they're simply implementing procedural rules, and that's Title VII. But there's some other statutes where they've implemented substantive regulations, and those include the Americans with Disabilities Act, the Age Discrimination and Employment Act, the Pregnant Workers Fairness Act, and that was one for which the regulations just came out very recently. And the EEOC took a very expansive interpretation of certain provisions of the Pregnant Workers Fairness Act. And maybe this is a good example of the type of things that will be subject to challenge under this new decision by the Supreme Court. There were two issues. One was Congress used the term related medical conditions to pregnancy and childbirth. It didn't define what it meant by related medical conditions. And the EEOC and its regulations included a whole host of things as related medical conditions: lactation, abortion, menstruation, fertility or infertility issues, contraception. There will undoubtedly be challenges to that broad interpretation of related medical conditions. The question will be, are those things really medical conditions that are related to pregnancy or childbirth? In one sense, they are in a very broad sense, but in a statutory sense, the court may say you've gone too far. Those aren't really related to pregnancy or childbirth. They are in the big broad scheme of things, but not for purposes of construing a statute. So that may be subject to challenge. The other thing that may be more relevant to most employers is that the Pregnant Workers Fairness Act requires reasonable accommodation to pregnant workers, and unlike the Americans with Disabilities Act, it also allows or requires in certain instances reasonable accommodations of the essential job functions that an employee may perform. And the statute itself says in order for there to be an accommodation of an essential job function, a couple of things are necessary. One, the condition that requires the accommodation has to be temporary. And second, the uh, reason for the accommodation has to be expected to end in the near future. The EEOC has interpreted both of those terms to mean 40 weeks, which is the standard length of pregnancy. Um, I think that is an area that's likely to be challenged by employers because you would think if Congress used both temporary and near future, they must mean different things because they would have otherwise just used the same word in both instances. So I think there's a big question about whether that really can reasonably be interpreted as the EEOC has done in the regulations. And so an employer who is faced with the EEOC saying that somebody may have to accommodate a pregnant worker by taking away essential functions for 40 weeks may challenge that in a lawsuit and say, well, that's not a reasonable interpretation of the statute. Maybe the near future means 6 weeks or 8 weeks, but it certainly doesn't mean 40 weeks. So the contours of what's required under these statutes are going to take quite a while to play out in the courts so that we know what the real rules are.
Gotcha. Yeah. What about other areas of, discrimination or harassment that are typically fall under the EEOC or even things like pay equity?
Sure. So let's start with discrimination and harassment because in most instances, those statutes tend to be more prescriptive in nature. There's more detail in the statutes than there are for example, the Pregnant Worker Fairness Act, which has very vague and general terms that aren't defined. Um, the other thing that relates to most areas of discrimination and harassment is that those laws have now been on the books for 60 years or 50 years or 40 years, and there is a large body of case law that has developed under those statutes and regulations. And so, to me, I think it's far less likely that there are going to be big changes in that area than in relation to some of the newer statutes. If there were an area where I think there might be some challenges and changes, it would probably be the Americans with Disabilities Act, just because there's so many more regulations in that area, and they
Hmm.
seem to go in many instances well beyond what's in the statute.
Gotcha. So, looking at other things like, we talked a little bit about, wage and hour. We talked about we've seen changes with overtime. We've seen changes regarding joint employer and things like that. I mean, those were areas that we already expected to see, challenges come up in courts across the country for the rule changes there. Uh, I would imagine that the new decision from the Supreme Court is only going to help those challenges now.
It gives those challenges a lot more tinder to put on the fire, basically. Those challenges will undoubtedly now incorporate the Loper Bright decision and the challenges to the regulations. And certainly at the Department of Labor, there are lots of areas where regulatory issues are likely to be subject to challenge now. There are some that are already ongoing. The wage and hour regulations that have been issued, the minimum salary basis test that applies to a number of the exemptions, the administrative, the professional, the executive exemption. Those are not tethered to anything in the statute. There's no provision that talks about a minimum salary basis for those positions. Those are probably subject to challenge. Some of the tip rules may be subject to challenge as well, although there's a little bit more in the Fair Labor Standards Act as it's been amended that relate tips or tip sharing and those kind of things. Those things that are in the statute are probably much safer than some of the broader regulatory efforts that DOL has made in that regard. Some of the OSHA regulations, OSHA just issued new heat regulations that
Mm,
apply on a nationwide basis. There's nothing in the statute that specifically authorizes OSHA to do that. There is the general duty clause in the OSHA Act,
Hmm.
and I'm sure OSHA will try to rely on that as a delegation of authority to OSHA to implement those kind of regulations. Supreme Court, as you may recall, in regard to the COVID regulations, was already somewhat skeptical about OSHA's overreach.
Hmm.
And I suspect that they may look at a number of OSHA areas in that same light on a going forward basis.
So, one thing that comes to mind with considering how long the Chevron deference was in effect. I mean, we're talking about 40 years here. I know things move slowly through Congress, but there are still quite a number of laws that have been passed since the mid 1980s. I got to imagine that when members of Congress were writing these laws, they did it with the understanding that federal agencies would then have the ability to interpret some of the broader sections of it. Uh, I know you're not a politician, you're an attorney, but I got to imagine this. Do you expect this is going to change then how Congress writes laws? Do you think it's going to lead to more specifics in I mean broadly, but is it going to have like enumeration of exactly what it means, or we're just going to write it the same as before and leave it up to the courts if there's a you know any controversy over it?
I think the answer is some of all of the above. There will be some incentive to Congress to put more specific provisions in legislation, which I think is probably a good thing, to lay out exactly what the mandates of the statute are and to require the agencies to enforce those mandates. But in the Loper Bright decision itself, Chief Justice Roberts, who wrote that opinion, specifically made reference to Congress's ability to delegate certain functions to the agencies. And so there are constitutional limits on the ability to do that. They have to have a specific delegation and it has to be within the scope of their authority. But I think we'll see some more of that from Congress, where Congress specifically says that we are hereby authorizing the Department of Labor or OSHA or the particular agency that's at issue to write regulations that cover the topic of X, whatever X may be. And then then the third thing is that I think Congress intentionally sometimes fails to provide specifics in a statute because they don't want to get mired in some dispute and then not be able to pass a bill that covers something because there's
Hmm.
too much division on a particular issue. And so they historically sometimes have punted and just let the courts decide, what the effect of certain things are later on down the road. And I expect that Congress will continue to do that some as well.
Good. So, uh, let's say hypothetically, I'm an employer in the hospitality industry. I'm learning now about the details of the new standard here. Uh, what should I do next? What should be my next steps?
Well, I think they're more, activity driven than anything else. They're based on what's happening in your workplace, and is there an opportunity to challenge a regulation or something of that nature, or if you become involved in a lawsuit relating to certain areas where there is regulatory guidance or rules that have been implemented pursuant to the notice and rulemaking requirements that are applicable to federal agencies. If it appears that you're subject to an area of regulation where the regulatory agency has gone too far, that may be a good defense in a lawsuit. So you want to make sure you keep an eye on those things. In addition, I think the other thing beyond merely trying to keep up to date with what the court interpretations of statutes have been, as we've gone along through years of development under these various statutes, there are going to be a lot more cases now where other employers challenge various provisions. And so you're going to have to keep up with all of those developments as well. We try and post insights on our website that make note of those things. So it makes it a little easier for employers to keep track of those. There are a number of other, law firms or websites that do the same thing. SHRM, for example, frequently makes note of major developments in regard to interpretations of regulations or statutes. So the HR folks in the hospitality industry and elsewhere will have a lot more to read probably than they did before, as if there wasn't enough before, right?
There's always homework. So, Randy, as we close out here, any final thoughts that you want to share just about the changes that we're seeing as a result of this case, or what it means generally for businesses?
Sure. I think generally for businesses who are faced with litigation based on regulations that are issued, a good example that comes to mind are the regulations under the Family and Medical Leave Act, for example. There are lots of intricate, arcane regulations that govern the FMLA and other areas as well. And if it appears in a situation that arises in your business that some of those interpretations are unreasonable, you should talk with your lawyers about whether it may really be an unenforceable regulation at this point. And then I think in addition to that, we'll see a lot of litigation over the next 5 or 10 years about the proper scope and interpretation of regulations that the government has been issuing. There was another decision that was issued on the last day of this Supreme Court term that said an employer can challenge the application of a regulation to it, and that the statute of limitations doesn't run until there's a final order relating to the particular employer. The government had argued that once the regulation is implemented, let's say it was implemented in 2010, the statute of limitations is 6 years. So anybody after 2016 was too late. And the Supreme Court said, no, the statute of limitations doesn't start to run as to a particular employer until they face a final order from a government agency or that would be subject to challenge. So things that may have been thought to be settled in the past in terms of regulations can be still brought up by someone using Loper Bright now, this obligation of the courts to look at whether the regulation's permissible and to make the best interpretation of the law. They have a new avenue to challenge final orders now. So if you're subject to a final order from the Wage and Hour Division or OSHA or the EEOC, you may have an additional argument to make to defend yourself against those things.
That's very good to know. Well, Randy, thank you so much for taking the time to break all this down for us, and thank all of you for listening. Stick with Hotel News Now for further coverage.
Hi, I'm Isaac Colazo, Vice President of Analytics at STR.
Hi, and I'm Jan Freitag, National Director for Hospitality Analytics for the CoStar Group. Tune in to our new show, Tell Me More, a hospitality data podcast.
It's a podcast on the global hotel industry, its current trends, what we're thinking about, and where the industry's going.
And we like to have fun with the data too. Find us on hotelnewsnow.com or wherever you listen to podcasts. Subscribe today.
Thanks for listening. This episode was recorded July 3rd, 2024, and produced and edited by Brian Roten. Go to hotelnewsnow.com every day for the latest in hotel industry news.